record now. All right, welcome to the final Zoom event for Hi-Phi Nation, where we do a bit more long-form discussion of the issues that arose from our last episode. And that episode is Justice and Retribution, and it's about the legitimacy of retributive justice. To remind everyone, this is the view of justice, where justice consists in the punishment of wrongdoers, punishment being the intentional infliction of pain and hardship on an individual in response to their wrongdoing for the purpose of condemning them or censuring that wrongdoing. And I'm joined today by one of the anti-retributivist philosophers featured on that episode. So Gregg, do you want to introduce yourself? And then also feel free to plug upcoming books, projects, events, things like that.
Okay, sure, yeah. So my name's Gregg Caruso. I'm professor of philosophy at SUNY Corning. I'm also honorary professor at Macquarie University in Sydney, Australia, and co-director of the Justice Without Retribution Network, which is housed at the University of Aberdeen School of Law. So I've been working a lot on issues having to do with free will and their connection to moral responsibility, and of late, more recently, to theories of punishment and retribution. And I'll just mention the two forthcoming books. One is actually entitled Rejecting Retributivism, Free Will, Punishment, and Criminal Justice. So I'm about to send that off to Cambridge University Press. Should come out at the beginning of the new year. And the other is a debate book with Daniel Dennett that's going to be titled Just Desserts, Debating Free Will, in which Dan Dennett and I debate our respective views on free will, moral responsibility, and punishment. So yeah, that's where I'm at right now.
Great. So I'm going to kick off the discussion, and then when people are ready to ask questions, then they can feel free to raise their hand, your actual hand or whatever the virtual hand is on Zoom, and I'm going to call on you. So Gregg, there's a lot of things that that the retributivists had said in the episode that you didn't get a chance to respond to. So I'm going to start with some of them. Beginning with something like this, what kind of free will do you think is required in order for people to ever deserve punishment? Every retributivist I talk to is a compatibilist of some form or another. And so they concede that we might not have free will in the strongest, libertarian sense, Kantian sense of free will. But what do you think is required for people to deserve punishment?
Yeah, so to begin with, I sort of define free will in neutral terms that doesn't bake into the cake any specific view of free will, i.e. compatibilism or libertarianism. So I define free will as the control and action required for what's called basic desert moral responsibility, i.e. the kind of moral responsibility that would make us truly deserving of praise or blame, punishment or reward, in the sort of purely backward-looking, non-consequential sense. So then it leaves it open as to how to satisfy those conditions, right? And so then my view essentially goes through and argues that both libertarian and compatibilist accounts fail to preserve that kind of control and action required for basic desert moral responsibility. So I'm what's called a hard incompatibilist. I reject both libertarian and compatibilist accounts.
So is it fair to describe your view as nothing satisfies the condition so as to deserve punishment?
Yeah, I mean, in theory, the conditions I think could be satisfied. So I don't think it's an incoherent demand. So like for example, agent causal libertarianism, I think would provide the kind of control and action necessary for agents to deserve sort of say retributive punishment. But I think we have good philosophical and scientific reasons for denying that agents have that kind of agent causal libertarian sense of free will. So in theory, I think that kind of account would preserve the conditions necessary, but I just think there are good reasons for arguing we lack it. In terms of let me just say something about the compatibilist accounts, because people like Michael Moore and others are theoretical or even pre-theoretical compatibilists. But I want to say a couple of things with regard to the connection toward retributive punishment. So I have, like, in the book Rejecting Retributivism, I develop 6 independent arguments against retributivism. Only 2 of them depend upon free will, okay? The rest of them have nothing to do with my kind of free will skepticism. And so I think that there are arguments that, say, weren't considered in the episode, and I think would still need to be addressed by say, retributivists. But in terms of the free will arguments, the first one is just a straightforward kind of argument for free will skepticism, and then I argue that given that free will skepticism is the only sort of reasonable position to adopt, we have to reject retributive punishment because free will skepticism undermines the idea that agents are morally responsible in this kind of sense needed for retributive punishment. But let me focus on a second argument that none of them really kind of address. I call it the epistemic argument. And so this only requires a much weaker form of skepticism about free will. So let's say you don't buy fully into my free will skepticism, or you're not persuaded by the arguments against free will. It's not at all clear that we are still justified, or the state is still justified in distributing punishment in accordance with desert. And that's because of a kind of epistemic set of considerations. So the argument runs something like this. Legal punishment intentionally harms individuals. And if we're going to intentionally harm individuals, we need a very high epistemic level of justification in believing we're warranted, that that individual deserves the kind of harm that we're going to impose on them. So if it's significantly probable that one's justification for harming another is unsound, then it's prima facie wrong, morally wrong, to harm that individual. And the retributivist argument for punishment and for inflicting intentional harm on others is the assumption that individuals are morally responsible in this basic desert sense. Yet the arguments, both provided by compatibilists and libertarians, for the belief that individuals are morally responsible in that basic desert sense, still face a number of powerful and unresolved objections. And so what I would argue is that the kind of compatibilist view that is used to justify retributive punishment doesn't reach the high epistemic standard needed to justify the kind of extreme forms of intentional harm we impose on individuals, for example, in the U.S. System of criminal justice. So the concern is something like, look, the debate about free will has been going on for over 2,000 years, and clearly there's no consensus on whether or not we have this kind of free will. Now, I have a view that thinks the philosophical arguments favor a particular kind of position, i.e. free will skepticism. But even if you're not convinced by that, my argument is that to justify the epistemic bar that's necessary for justifying the kind of intentional harm we impose on individuals, which includes isolation, depriving individuals of their liberty, separating them from their loved ones, in some cases, more extreme forms of punishment like the death penalty. That kind of extreme form of harm has to reach what I would consider a kind of legal standard of beyond reasonable doubt. So I adopt a kind of beyond reasonable doubt standard, just like we would adopt in criminal cases for liability, right? If we're going to sentence someone to jail for a crime, there's a presumption of innocence and a presumption, right, that the individual, the burden of proof is on the state to prove beyond a reasonable doubt that the individual committed the crime. Well, if one source of justification for retributive punishment is the assumption that individuals have this kind of free will, whether compatibilist or libertarian, and the kind of free will necessary for individuals to be morally responsible in the basic desert sense, that assumption also has to be justified to an epistemic standard of beyond a reasonable doubt criteria. And my argument is that no philosophical arguments in the extant literature, definitely not libertarianism, but I would argue also compatibilism, fail to reach that high epistemic standard. So the default position should then be to refrain from doing intentional harm on the grounds of just deserts. And so I propose something like a precautionary principle. In environmental ethics, we often adopt kind of precautionary principles. International organizations and the European Union have adopted principles in environmental policy based on precautionary principles that say, look, even in cases where we can't scientifically prove causality, let's say that smoking causes lung cancer, or that certain types of carbon emissions cause climate change. If we have reasonable doubt to suspect that human health and safety are at extreme risk, we should take precautionary measures even when there's not scientific, unison agreement on the causes of those potentially dangerous factors. So the idea of something like bisphenol A, we have a reasonable suspicion that bisphenol A, which is kind of BPA that's used in hard plastics, might cause harm to infants. And so Europe, for example, banned the use of BPA in say, baby bottles. Whereas the US sort of gives the presumption to the industry. But precautionary principles demand that the burden of proof be shifted. And I would argue that the same thing should be adopted in a situation like this, that where there's a kind of metaphysical uncertainty about a philosophical issue that has extreme practical import, in this case, retributive assumptions about moral responsibility and free will are going to have incredible practical application on the lives of individuals, that we should take precautionary measures in those situations and not do harm until we know that burden has been reached.
Adil is here and has had his hand up. Adil, you wanted to add on?
Thanks very much.
Yeah.
Greg, I'm so glad you brought up the epistemic argument, because I assigned one of your papers in my criminal law theory seminar, and the students really got a kick out of it. But I do have a concern about it, which is that the high epistemic bar that we place on intentionally harming others, doesn't that assume free will? That the reason why intentionally harming other people is so presumptively wrongful and so hard to justify is that intentional harming either uses people as a means, in this case, maybe to deter other crime, and to use an autonomous agent in that way is an affront to their dignity and a usurpation of their freedom. And once you remove place the question of free will and autonomy in question, can we really retain the notion that there's something incredibly hard to justify about intentional harming?
Yeah.
Such that the epistemic bar would drop from beyond reasonable doubt to preponderance of the evidence or something like that.
Yeah, I think those are sort of two separate issues, but the issue you're raising is an important one, and it came up in the episode as well, right? That one of the fears is that free will skepticism can't protect that kind of conception of human dignity. And just that concept of not using individuals as a means to an end, or some kind of Kantian conception of dignity, presupposes free will. In the book, I argue that's wrong. So in the book, I argue that we could preserve much of what people care about in that distinction. If, for example, I make a case that we could preserve everything we wish to preserve with regard to human dignity without presuppositions about free will. So if you look at people like Tadros's distinction between what he calls manipulative use and eliminative harming, for example, I think a similar free will skeptics can appeal to this. And in fact, I endorse in the book a prohibition on manipulative use. And what makes manipulative use wrong is that we use individuals as a means to some further independent end, right? Not treating them as individuals. Eliminative harming is the kind of harm that we might impose on an individual to eliminate the threat they represent, right? And on my public health quarantine model, that kind of harming is justified because of the right of self-defense and protection of harm to others. And that is not an affront to human dignity because we have independent moral grounds for thinking that kind of harm is justified. Whereas manipulative use, I argue, only presupposes a conception of personhood that could be divorced, I think, from Kant's own particular views about free will. So you could be Kantian without Kant's own particular commitments about free will. At least I would argue, and people like Benjamin Willhauer and Derval and others have kind of appealed to different notions of personhood that are independent of kind of conceptions about free will.
Is it independent of all accounts of agency, though?
it needs a certain kind of desert claim, but not a desert claim that's threatened by free will. So, for example, Benjamin Vilhauer separates personhood desert claims from action-based desert claims. And action-based desert claims are the kind of desert claims that are at, under dispute with regard to free will, whether an agent deserves to be praised or blamed, punished or rewarded for a particular act is kind of what's at debate in the free will debate. Personhood desert claims only need to pick out various aspects of persons, whether it be Kant's rationality or some other capacity that makes individuals deserving of respect. But that kind of desert, personhood-based desert, is not at threat and is not disputed by free will skepticism. The kind of desert that's denied by free will skeptics and basic desert moral responsibility skeptics is only a kind of desert that would apply to action-based desert claims. And those are the kind of desert claims that are being used in justifying retributive legal punishment. I could still defend, or at least I argue, still defend a kind of personhood-based desert claim, even if I reject action-based desert.
Adil, you had a follow-up?
I don't want to belabor, but Greg, can you give a short explanation of why manipulatively harming beings without free will or autonomy is still distinctively wrongful?
It's wrongful because it violates this kind of personhood desert. So persons as rational beings, persons as capable of adjusting their actions, as a means to an end, autonomy, all of those could be separated, because as a free will skeptic, I could argue that, we could acknowledge degrees of autonomy, we could acknowledge degrees of rationality. What we dispute is, and we acknowledge all the various distinctions compatibilists have made and the rich compatibilist literature that separates reasons responsive agents from non-reasons responsive agents and agents that have various types of control and agents that lack kinds of control. We just don't think that we think those criteria are important, but not in the way the compatibilists think. We don't think they're important in grounding basic desert claims. They're important for other reasons. So on my public health quarantine model, they're important for all kinds of forward-looking reasons, for example. They would also be important in deciding on what types of rehabilitation would be most effective. So an individual who's reasons responsive is susceptible to certain types of therapies that an agent who's suffering from psychopathy or some other forms of diminishment would not be. They would pose different forward-looking threats. But the fact that individuals have certain types of capacities isn't something the free will skeptic has to deny. And we could say individuals as persons who embody these capacities are deserving of a certain kind of inherent respect, and manipulatively using those individuals would be a violation of that principle. Even if we remove or deny agents are blameworthy or praiseworthy for particular actions.
So Greg, without all of the internal to the literature, academic philosophy way of describing, is this a good way of describing your view? You agree with Michael S. Moore, Kim Frazan, the people I presented in the episode, that we have a degree of autonomy. We have a degree of agency. You just don't think it goes above the threshold where people are deserving of punishment when they do wrong. It's below that. It's useful for other purposes, but it doesn't rise above the threshold for desert.
And there are good philosophical reasons and arguments for that, which go into all the philosophical arguments against compatibilism. And one was very shortly covered in the episode, the manipulation argument, right? Where an agent could be externally manipulated and yet satisfy all those conditions of autonomy and reasons responsiveness. And yet intuitively, we would think the agent doesn't deserve punishment, right? So like, let's say, a team of angels set up from the beginning of time that, this particular set of sex cells, the zygote, this set of genetic predispositions are going to be combined with certain conditions they control. So they set up everything in a deterministic universe such that this individual robs a bank on their 21st birthday. And everything is determined by these external manipulators, right? Yet you could still think that when that person engages in that action, they satisfy all the compatibilist conditions for free will. They're reasons responsive. they have a various degree of autonomy, they have a certain level of control over their actions, a kind of control that would be lacking, let's say, if they had late-stage Alzheimer's or a certain extreme severe form of brain damage. And yet, I think because of the external manipulation, we could say that even though those conditions are satisfied, there are good reasons and there are arguments for this, not just intuition here, that the individual wouldn't be morally responsible in the basic desert sense. And that's the sense that's required for retribution.
What? So convince me that your arguments are insensitive to the degree or harshness of punishment. Right? Why is it just no punishment whatsoever? Right? That's you. Like, why isn't it just like, okay, there are punishments like you have to write 100 times, I will not do this crime again, all the way to prison to like the death penalty, right? And we have like this range. And you're also accepting that there's a range of autonomy that you accept that we have, right? It just doesn't reach the threshold that the retributivist thinks it's already reached. But then you want to argue that there's no punishment whatsoever that we deserve.
No retributive punishment, right?
No retributive punishment, right? But retributive punishment for the retributivists could be, okay, write 1,000 times on the board, I will not do this again, right? I mean, they say we can be light about it.
Because the person deserves it, not because it would help
because the person deserves it,
or rehabilitate them, or
no, that's right. No, that's right. So it's you think it's insensitive to the harshness of punishment. You just think no backward-looking.
Well, let me say, like, they're separate arguments, right? So I think the epistemic argument has to be somewhat sensitive to that, because I do acknowledge in the epistemic paper that the lower the kind of harm, I think the lower the epistemic bar, right? So, for example, to mention Benjamin Billhauer again, he has a view that I don't necessarily endorse, but I'm sort of tempted by. He thinks there's an asymmetry between praise and blame behavior, for example, where, for example, praise could harm, but let's set that aside. I mean, if you overly praise children such that, you know, everyone wins a trophy all the time and they don't develop the kind of, you know, skills necessary for proper moral behavior, etc. So overly praising individuals could do harm. But let's just say in general, praise doesn't cause the same kind of harm as punishment or blame. And so for Benjamin Billhauer, the bar for what level of certainty or what level of conviction or warrant we have in believing individuals have free will would have to be lower. So if you adopted a kind of skepticism that isn't as radical as mine, that says we're not going to deny necessarily agents are free, but we can doubt that agents are free, right? A kind of doubt skepticism. That doubt may not be sufficient to warrant low levels of praise behavior, but may be able to prohibit harsh forms of punishment that remove liberty or that imprison individuals, or maybe even fines that could financially impair an individual's ability to pay their bills or affect their well-being. So you might be able to run an argument just on that epistemic argument that a very low level of harm or blame, like your example of raining on Hitler versus a Sunni, you know, might be justified with some level of doubt about free will, but I have other arguments, right? So the stronger skeptical argument is that the arguments for rejecting free will sort of went out. Under that, I think we have grounds for rejecting even low levels of blame and punishment, retributive punishment. The other thing I should mention is that although we're always focusing on the free will arguments, again, I develop all these others. And so Erin Kelly, I think, in her book, does an excellent job, for example, and I think this argument is underappreciated, a kind of misalignment that exists between the legal criteria for guilt and the moral criteria for blameworthiness. And so one serious problem for thinking that the state should or ought to be in the business of distributing punishment in accordance with desert is that it's not at all clear that the state is capable of properly tracking the desert of individuals in any kind of reliable way. And this is because if you look at the philosophical literature on moral responsibility and desert, um, most compatibilists acknowledge there are all these fine-grained kinds of exculpatory type situations or diminished capacities that would either reduce or totally excuse blameworthiness. And yet, those kind of cases aren't often captured in the very coarse-grained net of the legal criteria. So, for example, the insanity defense is one of the only few excusing conditions on mental capacity, and it's very seldom used. It's very hard to implement, and it's seldom successful. And there are numerous cases where individuals are found legally guilty, where I think the philosophical, and I'm talking about non-skeptics, the non-skeptics who believe in moral responsibility would acknowledge that there are all of these various kinds of conditions in which an individual could have diminished blameworthiness or be excused completely that the law doesn't capture. And so that misalignment means that even on the retributivist's own terms, injustices will be occurring because individuals will be punished under the legal criteria of guilt, where they're punished in accordance with desert, and yet aren't fully morally deserving of that punishment because of philosophical considerations that the law is insensitive to. Now, I go further than Kelly, or maybe Kelly goes as far too, so I shouldn't say that. So you might argue, well, that's a good reason for reforming the law, and a good reason to make the law more sensitive to the fine-grained mental capacities that might diminish responsibility. And so this is not a reason for rejecting retributivism, but a reason for reforming the legal system. But I argue that there are in-principle problems that make that impractical. And in the book, I call this the Pepa Argument. And the Pepa Argument is the poor epistemic position argument. And it's different than the epistemic argument I ran a minute ago. The poor epistemic position argument says something like this: for the state to be able to justify distributing legal punishment in accordance with desert, it needs to be in the proper epistemic position to know what individuals deserve. But since the state is almost never in the proper epistemic position to know what individuals truly deserve, it follows that the state is not able to justly distribute punishment in accordance with desert. And the reason why the state is generally not in a good epistemic position to judge the desert of individuals is that a whole bunch of factors affect desert. Things like social inequalities, things like racist, systemic injustices, things like mental illnesses and mental health issues and addiction issues. And the state is not usually in a proper position epistemically to know how those factors, A, played a role in the criminal act, B, how they affect the individual, whether they should be exculpatory or mitigating, and to what extent they should be exculpatory or mitigating. Plus, we have internal biases. We have asymmetric biases where we tend to see our own actions as more praiseworthy, where individuals who commit similar praiseworthy acts, we attribute it to luck, and so they don't really deserve the praise that I deserve. And we tend to see our own actions as less blameworthy than the actions of others, and we'll even adjust the level of control we think an agent needs for them to deserve to be blamed. So if we really want to blame them, we'll think that less control is required if less control is going to be capable of justifying that blame. So there are all of these reasons to think we're not in a proper epistemic position, both because the state is limited financially, limited in the time it could dedicate to each case, limited in tracking the kind of factors that affect an individual's deservedness and blame. And so since the state is almost never in a proper epistemic position to know what individuals truly deserve, I think that there are more systemic problems with distributing punishment in accordance with desert. And then there are, three other arguments I develop, again, that are independent of free will, but I think that's an important one.
Questions from participants?
I've got a question.
Yeah.
So about that particular argument.
Sure.
I guess the state is kind of making a decision about what the correct amount of retributive justice to impose on someone is,
Yeah.
even if they don't impose any, right? Then they're just imposing zero amount.
Yeah.
So, well, I mean, could it not be possible in principle for the state to say, yeah, there's all these reasons why we're very unlikely to get the exact correct amount to impose, but we are likely to get closer to the truth than imposing zero amount, and so it's still acceptable to try?
Yeah, I would argue a couple of things in response. I mean, one, I would deny the assumption there that they're often at least approximately close. Second, you have to think about the workaday real legal circumstances which most individuals find themselves, especially in the United States, right? So over 90% of cases are settled in plea bargaining in the United States, right? I think I got the statistics here somewhere. 97% of federal cases and 94% of state cases. And part of the reasoning is just we arrest, I think in the 1 year I have a statistic for, I think it was like 2010 or something, over 5 million people were arrested for some kind of criminal offense, right? The courts can't really properly adjudicate and give individuals fair trials for 5 million people. They can't process that volume. And so unfortunately, we've resorted to kind of plea bargaining. And this by no means matches up with the retributivist kind of utopian idea that we're really dealing in issues of desert. And the kind of punishments that individuals get are somehow even approximately close to what they truly deserve. Because the vast majority of those people who plea bargain because of economic reasons and because of inherently racist and biased reasons of the system. That is, they can't afford representation. They feel that if they plea and they get 3 months, even though they may be innocent, that's better than rolling the dice and going to trial where the alternative is potentially 10 years. And they're told that if they just plea bargain and admit guilt, so even the acknowledgement or admittance of guilt isn't really tracking desert here in any reliable way. And in fact, I would argue in the vast majority of that 90% of cases is far from accurately tracking. So I think that the retributivist in the real everyday workaday kind of world that we live in and the imperfect system that we have has to acknowledge that a great deal of injustice is occurring where individuals are getting disproportionate, according to their own principles of proportionality, are getting disproportionate punishments based on their own criteria of desert because we have no real good, reliable way of tracking desert. And let me add one additional argument that I developed later in the book, which I call the indeterminacy in judgment argument. And it has to do with the indeterminacy of judging both issues of gravity and proportionality, right? So according to retributivism, we're supposed to imagine this kind of magic ledger, where on the one hand in the ledger, we have gravities of wrong ordered in some kind of rank order, where the worst grievous wrong is at the top and the lowest kind of wrongs are at the bottom. And then we're supposed to look across to see what is proportional punishment for those wrongs. And in the book, I argument and actually document numerous cases in which cultural biases, cultural power inequalities, and all kinds of social prejudices can affect both our rank order of gravity and our ordering of proportionality. And even where we can agree on gravity, let's say like all retributivists can agree that murdering an innocent person is one of the worst kind of grievous acts we could commit. So let's place at the top level, maybe short of genocide, but pretty close to the top, right? And yet, almost no retributivists can agree on what they think is proportional punishment. So even if they could agree on gravity, we still have an indeterminacy in proportionality. For example, Kant, who was a retributivist, thought the only acceptable punishment for murder is death. Many contemporary contributivists do not favor the death penalty. And so they would argue that that's some kind of disproportionate punishment for murder. But yet, among that group, there's even disagreement as to what would be proportional. Some may say life in prison. But others would argue even life in prison is disproportionate and extreme and you know, beyond what's justified by some form of limiting desert. And so we can't agree on gravities and gravity rankings, and we can't really agree on proportionality. And when you actually look at both historical cases and cultural cases, even within contemporary US criminal law, like sentencing disparities between crack cocaine and powder cocaine, or different cultural attitudes toward proportionality and gravity about homosexuality in the past, where it was seen not only as a grievous wrong, but in some countries punishable by death, and actually, unfortunately, in many countries still punishable by law. And so you have a number of set of problems, which then, to me, leads me to believe that the kind of so-called or purported or putative protections that retributivism is thought to provide, it doesn't actually provide in actual practice. Because in actual practice, there's so much flexibility and indeterminacy in judgments about gravity and proportionality that we could pretty much justify whatever harsh forms of punishment we want to under a kind of conception of desert. Now, retributivists would respond that there's lots of philosophical literature about how to rank gravity and proportionality, but in the book, I deal with some of the proposals that come up in that literature. And most of them are, I would argue, are philosophically problematic in all kinds of different ways for all different kinds of reasons. Whether you adopt cardinal proportionality or some other form of proportionality, or go with more unanimous intuition type models. Again, there's all kinds of room for biases to come in and to affect our judgments about gravity. These are not purely free-floating, I think, assessments. They're embedded in cultural systems that have cultural attitudes towards certain kinds of moral norms. And so you can't really have a value-free conception of the kind of normative violations that deserve certain types of punishment. And so because it's so subject to bias, I think it's better to kind of abandon that way of distributing justice altogether, independent of these other types of arguments. Yeah.
Adel.
Yeah, so Gregg, that was really powerful. I'm just curious because I'm eagerly awaiting your book.
Yeah.
For your social quarantine model,
Yeah.
presumably you have some way of understanding how serious forms of criminal behavior are, such that certain forms of restraint would be appropriate and others not, and for how long and things like that. And I'm just curious, how do you conceptualize the gravity of criminal behavior and its relationship to constraint?
Yeah, right. So in the book, I propose a number of ways, because I understand the fears that, and some of those fears were expressed in the episode, right? That opens up the floodgate for preemptive incapacitation and incapacitating people who exhibit, harmful behavior but haven't yet committed a criminal act. I have what I think are successful replies to those kinds of considerations. But in terms of like judging sort of gravity, judging forward-looking risks of an individual, I always want to favor and weigh heavily individual liberty. And so in my model, for example, I argue, for example, that we should, like, analogous to the presumption of innocence that we currently have, we should adopt something like the presumption of harmlessness. And so the burden of proof should be on the state, not on the individual. And so the state has to reach as kind of, just like we would a high level of, a high, reasonable expectation of harm. The state has the burden of establishing that the individual, maybe beyond a reasonable doubt, has poses this kind of harm moving forward. And not only poses harm, but a kind of harm that would justify incapacitation. So for me, most types of harms are not going to be grounds enough to justify incapacitation. So most low-level nonviolent crimes for me would be better dealt with by other means. In fact, I highly advocate decriminalization of many forms of low-level nonviolent crimes. And this is particularly important in light of what's happening in terms of police brutality and what's taking place on the streets right now. Because a lot of these incidents arise where the interaction between the police officer and the African-American youth that leads to the death of that individual is triggered by a low-level nonviolent infraction. So, you know, for example, the one in Staten Island where the first person to actually utter the words, "I can't breathe," uttered those words after a police officer tried to restrain them by putting him in a chokehold. For what offense? Selling loosies. That is, he was essentially killed in an attempted interaction with a police officer for an illegal act, in this case, which is it's illegal to sell single cigarettes. So a lot of these broken window policies that cause interactions and trigger essentially, you know, police brutality, incidents of police brutality occur because we've legislated too many infractions. And those infractions are overly policed and enforced in certain communities and not in others, right? And that's the racial part that people are screaming out against. So I would say for most of those kind of offenses, decriminalization is actually sort of necessary. We need to relook at the law, what infractions really do pose harm to society. In terms of the kinds of harms I think are justified to incapacitate, they'd be limited to, I think, you know, violent types of offenses that jeopardize, you know, real harm in terms of individual well-being and autonomy, maybe property as well, like, so, you know, extreme forms of theft. But the burden, I think, has to be met by the state. And the reason I don't think preemptive incapacitation would be generally justified on my model is there's all kinds of principles, I think, and legitimate reasons for thinking the state can't satisfy that burden of proof. So, for example, you know, given the limitations of our current kind of screening methods for harm, given their invasiveness, we usually have to hold someone and limit their liberty to observe them in the first place, and given all the potential for false positives, I argue in the book that we should adopt the kind of epistemic skepticism about an individual's judgments about dangerousness moving forward. So my preference, and I think I could argue for it on legitimate philosophical grounds, is that the individual has to commit a criminal act first, because that's the best you know, previous behavior is the best judgment we have for future risk. And it's an imperfect world, just like judging proportionality is imperfect, but I think it's more perfect and protects individual liberty and better. And I think in my case, more humane. I think we get more humane results. You know, and I acknowledge that there are these crazy philosophical thought experiments that you can come up with. So here, I think, is one of the harder, if I could raise an objection to my own view. In fact, Dirk Purenboom raises this concern. So he says, imagine we have a case where it's almost certain this person's going to commit a violent criminal act in the next. So he comes up with this really ingenious case. Like someone slips a drug in this individual's coffee, and unbeknownst to them, slips a drug in their coffee that makes it 100% certain that over the next week, they're going to commit a string of gruesome murders. But the drug's going to wear off of the week. Would we be justified in incapacitating that individual for that week, right? And my strong intuition is yes, right? Now, a retributivist could object to that, right, case, because you're now limiting liberty. But in a certain sense, I think my intuition might be more widely shared in this case, because I think even though the individual hasn't yet committed a criminal offense, I think most people would think there were grounds, or that we would be justified on various rights of self-defense and protection of harm to others to limit this person's liberty. So what I would say first is retributivists are usually not just pure retributivists. Most of them endorse something like retributivism plus, i.e. retributivism plus they acknowledge that there might be other conditions where triggers of incapacitation might come in, or certain types of special cases that aren't going to be dealt with purely on retributive grounds. So they acknowledge mental illness cases, for example, and they might even argue that this person in this drugged coffee case is more analogous to someone with severe mental illness and isn't responsive to reasons and such, and that's why we could incapacitate them because they have diminished capacity. But I would argue then, well, I could make the same move. I could appeal to the same kind of diminished capacities in cases where agents aren't reasons responsive, to say those might be special circumstance cases where preemptive incapacitation would be justified, and you, the retributivist, you acknowledge these cases exist anyway, and then say in the normal functioning individuals, in the normal reasoning responsive cases, we should respect that aspect of personal autonomy in those cases and allow the individual to commit the offense first, because that's the only real epistemic grounds we have for judging harm reliably for reasons responsive agents, because we can't know with any level of certainty in terms of future prediction. We don't have crystal balls. That a reasons responsive agent poses that kind of threat in almost all everyday real life cases. And in the weird extreme cases where they want to come up with a trap for my model, I think it's equally, these would normally be equally cases that are problematic for all theories, and most theories would make exceptions for. And then lastly, I add to that a certain additional wrinkle that says, and I think Frazans raises this in her post-episode interview, that there are lots of cases where those individuals might commit criminal infractions leading up to the crime that itself might give us grounds for some sort of intervention or sanction. So for example, if I start making violent threats against a woman I have stalked who's turned down my advances, or I threaten her online or through some electronic means, those might be deemed criminal offenses in themselves. So it's not just that the individual has not yet committed any criminal acts. They've created some lower level nonviolent criminal acts that are indicative of a future violent crime that might themselves give us some grounds for maybe incapacitating them for observational purposes or for some other measures. So I think that there are a number of ways to deal with the kind of counterexamples that people come up with that my model can easily adjust for. And I think better, in some cases, better adjust for than alternative.
Hey, Greg, we are out of time.
Okay.
Yeah, so thank you for joining us on the final Zoom event for this season of Hi-Phi Nation. That's it, folks. That was the season on criminal justice. Thank you. And
I just want to thank you for your excellent series, both this year and in the past. Hi-Phi Nation is a real contribution to philosophy and public philosophy, and I want to thank you for doing such an excellent job making philosophy accessible for people.
Great. Thank you, Greg. Thank you, everybody who's here today. Adel, Emma, Nathan, Philip, Harsh, everybody who's here. And thanks for your support throughout the season. I am expecting to be back for the next one.
Excellent. Excellent. That's what we wanted to hear.
Great. All right.
Thank you, guys.
Everybody have a great rest of your Monday.
Thank you so much, Barry. Thanks, Greg. Great job.
Thank you.